Right now, there is a lot of confusion about VAWA, and I'm simply seeing advice from other lawyers that is wrong. And this bad advice is causing people who qualify to delay filing or make decisions that put their case at risk. So I am going to share my top 4 VAWA secrets that other lawyers are not telling you right now, including whether or not VAWA is safe, how long cases are really taking, and what protection it can give you from ICE. So if you are thinking about filing for VAWA or have already started the process and you are not sure what to expect, then this video is for you. Okay, first, I want to talk very honestly with all of you because I know that you are very scared. I'm hearing this every day in my office. I'm talking to people who qualify for VAWA and should be moving forward, but instead they're frozen in place because they are hearing things telling them what to do or what not to do. I know that some of you are maybe hearing from some lawyers that it's not the time to file right now. I know that you're probably seeing videos that are saying that VAWA has changed. I know some of you are thinking, what if I file and make things worse? So let me slow this down and make it very clear to you. VAWA did not change. The law did not change. And your right to have not disappeared. What USCIS has released is a policy update, not a new law. And underneath the law, the standard is still the very same of any credible evidence. That means that USCIS cannot legally require police reports, medical reports, or proof of physical injuries. They never could. And now, are they saying they want to see more evidence? Yes. Are they asking more questions? Yes. But that was already happening, even before this update. We have received a record number of requests for evidence this past year on even extremely strong cases that were well prepared. This has just become part of the process, but this should not deter you or prevent you from filing, especially when you qualify. And it has not stopped us from getting our cases approved. So when you hear people say that VAWA is getting harder, all that it really means is that it's getting a little bit more challenging. But this is fine as long as you know how to prepare your case and you know how to make it strong. And here's the most important part. It is still possible to get your VAWA approved even without a lot of evidence. This has not changed, and even the policy manual update makes it abundantly clear that any credible standard still exists and is still the one that USCIS will be using to adjudicate its cases. However, this policy manual update means that you should take more time even now to prepare your case, especially where an affidavit is concerned. A weak affidavit can definitely trigger a request for evidence. And every request for evidence increases the chance that you may not be able to successfully respond and thus get your case denied. That's why in my office, we take our time. Unlike other lawyers, we don't ask clients to write their own affidavits. Instead, we spend hours interviewing clients, sometimes over multiple sessions, and we take time to carefully craft an affidavit based upon the client's own experiences. Because we understand that USCIS is not just looking for bad conduct from your abusive relative, but they're looking for patterns of power and control over how your life was changed by your abusive husband or wife. And they're looking for why your spouse may have wanted to hurt you in the first place. So showing these patterns of control and fear and power take time and take careful deliberation. So I know some of you are still asking, isn't it safer to wait? The fact of the matter remains that if you are undocumented and you have nothing to help you get status in the future, then you are actually in a much more precarious and risky position than by getting in your application and striving for the protection that VAWA affords you. Without a pending application, you have no paper trail, no pending leverage in the legal system. And the truth is, whether people want to hear this or not, this is exactly what the administration wants. They want you to give up and walk away without asserting your rights. And they want you to be scared so that you give up and you leave this country. But doing nothing while you stay in this country is only going to leave you vulnerable. And I believe it's best to apply for protection while the protection still exists. So it's best to get yourself in line for this case. And I'll share with you in just a moment that it can still protect you even in ICE encounters. And just think about the peace of mind that this could give you during these crazy times. Now, I'm not telling you to file blindly. I'm telling you to get informed. I'm telling you to prepare your case in the right way and to understand that doing nothing does not make you any safer. And just know that the longer you continue to wait, the longer the wait time for a decision is going to get. Speaking of the long line, let's talk about wait times, because this is where a lot of people are getting anxious and confused. The first thing that I want to address are receipt notices, because that is the number one thing that I am getting asked about. If you filed a VAWA case over the past few months and you still have not yet received your receipts, please rest assured that this is actually becoming the norm right now. We are currently seeing receipts take anywhere from 1 month to 6 months to receive, and we are experiencing a particular backlog for cases filed over the summer months. I have some clients who are getting their receipts within less than 30 days of filing, and others for whom we are still waiting over 5 months. I've even seen cases that get filed at different times get receipts in the reverse order. For example, for cases that we have filed in December, we already have our receipts. But for the cases that we filed in June and July, September, October, we still do not have those receipts. It makes zero sense and it is extremely frustrating, but this is how USCIS is working right now. It doesn't mean that there's a problem with your case or that there's a problem with your filing. It just means that things are not being done efficiently at USCIS. The system is extremely backed up. This delay is happening even before cases can begin to start being processed, because cases are likely sitting inside of the mailroom without getting receipted. And I know that waiting months for a receipt can feel terrifying, especially when you are undocumented and expecting on immigration to issue these receipts to show proof that you have something pending. But the expectations from the past no longer match our current reality. It's simply not how immigration is working, and this is the metaphor that I like to use. Picture that USCIS is like a drive-thru. There is a long line of cars waiting outside, and that line is getting longer with every passing minute. Inside, there are only a handful of employees, and those employees are at the same time trying to take orders, prepare the food, pack them up, and take payment and distribute the food to the customers outside. Even if you add one worker, that line is not going to get much smaller, and the food may not come out that much faster. In fact, the line is probably going to keep getting longer by the minute because cars are still continuing to pull up, no matter how quickly the food is coming out. And this is pretty much what USCIS looks like right now. So try to stay calm, even if your receipt is taking months to receive. It does not mean that anything is wrong with your case. Again, it just means that USCIS has more work than they can handle. Next, let's talk about the overall VAWA timeline. Here, people need to have some realistic expectations. Right now, I am taking VAWA I-360 applications take anywhere from 3.5 years to 4.5 years to get approved. Some cases move along faster and others take longer to decide. But this is the general range that we are seeing. However, once your VAWA is approved, your green card application is another separate process and another step that has its own additional timeline that is going to be governed by your local office practices. Once your VAWA is approved, your case has to be sent to your local field office, and there you might have to wait for an interview or for other requests for evidence and get in line for an interview if requested per the rules at that office. Depending on which field office your case gets sent to, which is going to be dictated by where you live, this step of the process can take anywhere from 3 months to an additional year. So be prepared for that. Just this past week, we had 2 green cards for our VAWA clients approved. And when I looked at the information, I saw that the VAWA was actually approved roughly 1 year ago, and they were both filed roughly 4 years ago. So overall, these cases took about 4.5 years to get the green card processed. This is another reason why you should get your application in line, because delaying does not make you any safer, and because these things are taking so much time with the backlog expected to grow. It's better to get your case in sooner rather than later. So get your case filed while the wait times are still reasonable. Next, let's talk about RFEs, because this is causing a lot of fear. Let me be very clear. A request for evidence is not the end of your case. And it also doesn't mean that your case is not a good case. As I mentioned earlier, last year we received a record number of RFEs on our cases, which I personally know are excellent cases with strong evidence. Even several cases had evidence of sexual abuse and physical abuse. So why is USCIS even issuing an RFE on those cases? Well, we even had several cases receive the same RFE multiple times. So what is actually going on? In many cases, RFEs are being issued because the officer may not have done a deep review of the case, or because it has been sitting there a long time and they simply need to show that they have performed some sort of action to keep it inside of the regular processing time. Sometimes it means that the officer who is looking at your case is a new officer who is not well trained. So they may just send you an RFE as a result of their lack of training or because of the delayed timeline on your case. And I want you to understand how common this is. I have seen RFEs that make very little sense legally speaking. I have seen RFEs that ask for things that are not even required by the law. And I have seen RFEs on cases that involve serious emotional abuse, serious physical abuse, and other types of violence. And obviously, the RFE is still alleging that this is not enough to show extreme cruelty or battery, which is blatantly untrue and incorrect. So the RFE may have been issued by the officer because the officer was overwhelmed, ignorant, or just not paying attention. And how do I know this? Because as I mentioned earlier, we even got multiple RFEs issued upon the same cases even after we had already submitted responses. And all of these RFEs were asking for details that were already well explained through the affidavit and the evidence. So it just goes to show that RFEs are not actually a personal revelation upon your case and are usually due to other factors. And these days, officers are sending out RFEs that are simple templates that just require a check mark, which shows even further that they really don't even have to review your case closely before they issue an RFE. In fact, they probably are not even reading the affidavit before they issue a request for evidence. So don't freak out if you get an RFE. Take it as a sign that your case is still alive and that you have more chances to prove what happened to you in your life. USCIS does not issue RFEs on cases they have decided to deny. USCIS issues RFEs when things are unclear or when they just don't have time to review things closely. Other times, RFEs may be issued when there's inconsistent information inside of your case, in which case you do have to be very careful about how you respond. But remember, the worst thing that you can do when you receive an RFE is to panic and not do anything. Panic is what gets people into trouble, and it causes them to over-explain and not think clearly, or send new information that may create more problems. You want to make sure that you are responding carefully, consistently, and thoroughly, making sure to address anything that USCIS brings up. But as mentioned, USCIS is not even going into detail in their current RFE template, which is kind of a blessing because they're not really pointing out what is exactly wrong or what they have a problem with, which usually gives you a little bit more room to re-explain what happened to you in your case. And I know that RFEs are frustrating and that they shake people, but as mentioned, it is just another chance for you to prove your case. Next, I want to tell you about something that happened very recently. We have a client in Minnesota who was caught up in the ICE raids and protests that were happening in her city. We had filed her VAWA case a couple of years ago. She had received an advance parole card through this case, which she had used to travel and re-enter the United States. She had a prima facie determination and thus had some protection in place. And if you are watching the news right now, you know what a war zone Minneapolis is like right now. There is heavy enforcement, ICE officers everywhere, fear, and people being grabbed, even if they're U.S. citizens. In this instance, my client did get snatched and did get grabbed by ICE officers. However, she showed these officers the fact that she had an EAD and a case pending, and they asked her, how did she enter the United States? When she was able to respond that she entered with advance parole, they discussed amongst themselves that they were not allowed to hold her with this. They went back and forth, they checked her information, and they released her, telling her to come and check in. Now, I really want you to think about the fact that having this case in place helped save my client from getting detained and God knows having what done to her. This is someone who was undocumented before. This is someone who would have had zero protection in place had she done nothing. And this is someone who, without her VAWA filing, could have ended up in detention and even removed from the US. And this is what I mean when I say that filing something is better than sitting there like a lame duck. Once a VAWA case is properly filed, you are no longer invisible. You are actually seeking shelter underneath the law, and you are creating a record asserting your rights. You are seeking protection underneath something that Congress has created and set as law for you. Is it perfect protection? No. Is it a complete guarantee that it will prevent you from negative interactions with ICE right now? No. but it is very different than walking around with zero protection, especially during these times. My name is Moumita Rahman, and over the past 15 years, I've helped thousands of clients across the United States. This means that I know what USCIS is looking for in their immigration cases and what you need to do to get your case approved. If you would like my help on your VAWA case, give us a call at 212-248-7907. We are based in New York, but we help clients all over the United States. And if you want even more secrets about VAWA that other lawyers won't tell you, be sure to watch my next video. In it, I break down things about VAWA that most attorneys do not explain clearly, especially when it comes to evidence, timing, and how to avoid mistakes that can quietly kill your case. I'll include a link to that video here. Click next and I'll see you there.